So in the Motorola versus Murray case, we are looking at um, we're looking at the rules that govern the admissibility of expert evidence. And let me just tell you, this is a short thumbnail introduction of this topic. There's a whole class that Professor Moriarty teaches on expert evidence. It is incredibly detailed. It is something that will have very specific rules for whatever the particular thing it is that you're trying to get an expert to testify to. So if it's fingerprint evidence, if it is false confession evidence, if it is physics, and actually with physics, that's a huge category. If it is the movement of a proton in a nucleus, or if it is, the way that that Europa circles Jupiter. These are all very specific things that you might be called upon to have an expert to testify to. So for each particular area of expertise, there is very likely to be a body of law that addresses that particular area. And of course, as you'd expect, product liability and particularly drugs are the primary area where this type of issue comes up again and again and again. So when you're faced with a question of expert evidence, go and research the particular area of expertise you're looking for. It's likely with something that's heavily litigated, like drugs or manufacturing defects and other things. You will have very specific rules that will govern the type of evidence that comes in. We are scratching the surface when we look at the cases we're looking at tonight or today, depending on when you're viewing this. So I've given you the Motorola versus Murray case, and the facts really aren't that terribly relevant to the analysis in this case. Just to kind of fill you in on that, this is a case in which the plaintiffs claimed that frequent cell phone use was causing brain damage, and they wanted to introduce an expert who would testify to that particular conclusion. The only question in the version of the case that you have is this: what is the standard that governs the admissibility of someone who claims to bring specialized training to a question like this? What is the cause? What is the cause of the brain damage in this case? Could the cell phone use have been a contributing factor? Very specialized expertise would be required, whether that's statistical, whether that's neurological. There could be all kinds of expertise that we bring to the table to show this. I would kind of be fascinated where you got your control group of people who don't use cell phones to do a comparison. I guess you would look at data pre-cell phones. That actually could provide a control group. But in the modern world, good luck on finding someone who doesn't frequently use a cell phone. So the question in this case is whether the District of Columbia Court of Appeals is going to be using what used to be the standard. It was actually created in the DC Court of Appeals, a case called United States versus Fry that looked at lie detectors. And in that case, the court held that lie detectors could not be admitted because they hadn't reached the standard of general acceptance in the relevant area of knowledge. So the Fry standard was very restrictive. Basically, the thing being testified to, or the results of a scientific test that was administered, had to be accepted as appropriate, as useful, as bringing some real information to the table by the people who worked in that particular area. So does law enforcement generally regard lie detectors as being accurate enough to rely upon? That would be a relevant community for expertise on lie detectors. So the question under that was, unless basically the entire scientific community had come to a consensus on an issue, you couldn't tell the jury anything about a person's theory within it. So climate change, great example. Has climate change reached the point of general acceptance in the scientific community? That one, the answer would probably be yes, at least if we were looking at this in any terms of mathematical sense. Climate change is a great example, though, because what if you wanted to bring in a scientist who denied climate change? And they exist. They are definitely the minority. They're in the tiniest of minorities in the scientific community. But these folks aren't ill-educated. They are relying on certain scientific principles that those in the overwhelming majority regard to be incorrect. But they are relying upon scientific principles. So if we were to look at this under the Fry test, whether the notion had gained general acceptance in the scientific community, climate change has absolutely gained general acceptance in the scientific community. And so under that theory, the Fry standard, only those scientists who offered their conclusions that human beings were changing the temperature of the planet in a bad way, in a more heated way, or warming the planet, only those scientists could testify to a jury under the Fry standard if global warming were somehow at issue in a case. Under this new Daubert standard, and it is pronounced Daubert, a friend of mine actually met the plaintiff in the Daubert case, and it's not Daubert. You'll hear a lot of people say Daubert. It actually is Daubert. The standard in the Daubert case is much more kind of loosey-goosey. It looks not to general acceptance, although that's something that the judge can consider. The judge is supposed to consider whether the methodology being used is scientific or is valid within the norms of the profession in which this testimony is offered. So you look at whether the methodology is scientifically valid and whether that methodology is appropriately applied to this case. Judges are trained in precedent, not in experimental design. So, it really is kind of odd to have a judge overlooking the shoulder of someone who purports to be a scientist who comes in with his PhD from Caltech or Stanford or wherever and offers that this is valid science, particularly when that person is in the minority. So how do judges go about analyzing this? Well, the court says in Daubert, the Supreme Court in Daubert versus Merrill Dow Pharmaceuticals, you look at several things. You look at the studies that have been done, the analysis that has been done. Has it been peer-reviewed? Has the methodology, because if you get published in a scientific journal, unlike a legal journal, it's been reviewed by people who know what they're doing. People have looked at whether the method that was used was appropriate. It also looks at the error rate, because if we're looking at any kind of a scientific study, it's not like everything is, causation stories are not 100%. If you had organic chemistry as an undergraduate, I think I've mentioned this before, the entire world can be explained by the second semester of organic chemistry. In the first semester of organic chemistry, they tell you this blob plus that blob gives you that blob. Well, in the second semester, they level with you. They say that blob plus that blob will give you some of that blob and some of that blob. And depending on what the temperature is, more of one than the other than at other times. And then there's a bunch of junk that's created by your experiment. You get some of this stuff, then you get some waste, and how much of each one you get will vary based on temperature, but you're going to get some of one, some of the other. Same thing with causation stories. Every time a person takes a drug that's supposed to cause it, as in the Merrill Dow case that you haven't read, but it's referred to here, every time a person takes a particular drug, it doesn't mean that that person's child will have birth defects. That's not what causation means. It means some of the time this will happen, and it will happen to a greater extent. So the question is, how many things fall outside of your model? How often is this thing wrong? If you say, that there's a 20% greater likelihood of causing birth defects with this thing, if you look at different populations, how far outside of the error rate does it fall? Kind of like with the margin of error in the polling for the current elections that we have coming up. What is the margin of error? How likely is this causation story you're telling to be wrong? If the margin of error for a 3% causation, 3% of the time that people take these drugs, birth defects will develop, and our margin of error is 4.2%. Well, then you really don't have anything valid at all. So error rates are absolutely relevant. It's also relevant whether this person is an outlier, whether this person whether this theory has gained acceptance in the scientific community. So Daubert says, if the methodology is right, we don't care who's accepted it. So long as you are using quote unquote good science, it'll come in. And if things that have been long accepted in the scientific community were not based on good science, then it won't come in. They don't give us an example of something in that category. In the category of not accepted but using good science, could be some scientist who says that climate change is not real, or that we're not affecting the temperature of the planet. There is tiny number of people who would otherwise, who are legitimate scientists, small minority. Those folks could potentially testify under the Daubert standard, but not under the Fry standard that requires general acceptance. It is generally accepted in the scientific community that human beings are causing the planet to warm. It is generally not accepted that we're not. Those are outliers. But if we looked at the science, and some of these folks, and scientists can disagree with their conclusion, but there are serious scientists, small number, who have come up with claims that that's not the case. They've been criticized, but that's legit. That's in balance. That's what you have trials to determine. So with Daubert, and the court in the Motorola case adopts Daubert, the trial judge is not looking at whether what you're claiming as an expert is something that other people in the community accept. The judge is engaging in the very daunting task of asking, how did you come up with your conclusion? And does that conclusion or that methodology satisfy scientific rigor, regardless of what the conclusion is and regardless of who agrees with it? Fry asked simply, do most people in the scientific community agree with it, your conclusion? The Daubert test says, do people in the scientific community think that you structured your experiment properly, even if they disagree with it? And that's fodder for cross-examination if they disagree with the inferences you draw. But were you engaged in a scientifically rigorous, falsifiable claim? If you're wrong, can we show it through further experimentation or analysis? Or is this just some hooey? Fry wouldn't ask if it was some hooey in the process, so long as scientists accept it. Daubert asks, how did you get to your hooey? We'll let the hooey in, but how did you get there? If you got there in a legit way, fine. Fry says, if it's hooey, it's not coming in. Daubert is about methodology, and courts are about evaluating the methodology. Fry asks about conclusions and whether people accept those conclusions and those methods of testing that you are bringing in. So again, this case and this discussion merely scratches the surface and lets you know that if you have an expert evidence question, and this will certainly do you just fine for the bar, But if you have an expert evidence question, delve deeply into the specifics of what you're looking at, because there's so much litigation out there on this, particularly in the drug area. But on fingerprints, on lie detectors, which was the case in Fry, on all kinds of different types of scientific or professional evidence that's offered under this expert standard, that you will find something likely on your specific question, and there will be very specific answers in the case law as to what methodologies are regarded by courts as legit for the type of expertise you're looking at. And if this is a topic that interests you, definitely take Professor Moriarty's expert evidence class, entire class basically devoted to just this one question.